Hello, everyone, and thanks so much for joining us for a discussion on how to break into antitrust as a young lawyer. We have an hour together, and I'd like to spend the first 50 minutes or so with our panelists, and then leave the last 10 minutes for any questions the audience might have. At any point, you should feel free to send me a question through the chat, and I'll try to get to as many questions as possible. But now I'd like to introduce our three distinguished panelists. Lauren Weinstein is a partner at MoloLamken, where she represents both plaintiffs and defendants in the antitrust disputes at trial and on appeal. In addition to writing on developments in antitrust law, Ms. Weinstein serves as the co-chair for the ABA's Antitrust Litigation Committee. Earlier in her career, Ms. Weinstein served as a law clerk to the Honorable M. Margaret McGowan of the United States Court of Appeals for the Ninth Circuit and the Honorable John G. Coydle of the United States District Court for the Southern District of New York. She received a BA from Northwestern University and a JD from Harvard Law School. Jen Greenblatt is a partner at Goldman, Ismail, Tomaselli, Brennan, and Baum. She is an accomplished antitrust litigator specializing in defending corporations against antitrust class actions. After graduating from University Law School, Ms. Greenblatt served as a law clerk for the Honorable Richard Clifton of the United States Court of Appeals for the Ninth Circuit. Kevin Schock is a senior counsel for marketing and performance analysis at Intel Corporation. Before joining Intel, Mr. Schock was an antitrust litigator at Perkins Coie. He received his undergraduate degree from Oregon State University and his JD from Penn State Dickinson Law. I'd like to start by asking each of our panelists about the paths that led them to antitrust law. Starting with you, Kevin, coming out of law school, did you know that you wanted to practice antitrust?
I didn't. I actually didn't take antitrust in law school, but I went into practicing as a first-year associate with an open mind. I knew that there was lots about the law that I didn't know after 3 years as a law student, and I wanted to touch as many things as I possibly could, remain open to as many things as I possibly could. And I actually think antitrust represents perhaps a unique opportunity to maintain that openness throughout your career because it touches and concerns just about everything we do as lawyers and in the law. But where I actually, got linked in or linked up with the antitrust bar was as a result of being seconded to a generic pharmaceutical company who was dealing with some compliance issues surrounding a consent decree that had been issued by the FTC, touching and concerning antitrust-related issues. So I would just say, like, my openness to exploring complicated, nuanced areas, opportunity sort of striking is what drove me to become an antitrust practitioner.
And Lauren, you had started your career as a law clerk and then joined a general litigation practice. Had you even taken any antitrust law courses in law school?
No, I guess to date, I haven't taken an antitrust class because I didn't take one in law school. I haven't taken one since. Like Kevin, when I came out of my clerkships, I didn't want to choose a practice. I thought it was silly to ask somebody with, 2 years of experience out of law school to decide what they wanted their practice area to be for the rest of their life. I still think that's kind of silly. So I joined a law firm. I knew I wanted to do litigation, that I knew. But I joined a litigation boutique that wouldn't force me to choose a practice area. And so I got exposure to many different types of cases. I did, securities work, represented foreign sovereigns in the Supreme Court. Of course, antitrust snuck in the mix. And it wasn't until I was a bit more senior in the organization and started to think about where I could really add value in terms of business development that antitrust got on my radar. In the last 5-10 years, we've seen huge developments in antitrust law and more interest in this area of law than I think we've seen in decades, bipartisan interest, interestingly. and lots of litigation results when there's more interest. So this was an area where we didn't have a specialist at my firm at the time. In discussions with some of the senior partners, they said this might be a good area to think about it and see if you're interested. And I did. The first case that I worked on actually was the Apple versus Pepper case in the Supreme Court, which had to do with who is a direct purchaser withstanding to sue under the federal antitrust laws from Apple's App Store. And I had experience as a Supreme Court practitioner and used those skills to kind of like an entree to antitrust work and represented a group of leading scholars in that case, and then kind of became I started writing about antitrust law, speaking about antitrust law. We ended up being on the same side of the issue as the Supreme Court, which always helps. And that's kind of how I got started.
Jen, you don't have what we might think of the traditional antitrust background either. Is that right?
That's right. Much like Lauren, I think I sort of lucked my way into the practice of antitrust, and sort of by way of doing trial work more generally. At my firm, that's sort of we're another litigation boutique, perhaps in competition to Lauren's, but we do trials across a variety of subject matters, and was privileged to be working a little earlier in my career on an FTC action challenging a large merger, quickly followed by getting involved on the defense side of what the plaintiffs call pay-for-delay antitrust cases, and we would refer to instead as reverse payment litigation. So that was my entree into antitrust. Never took it in law school. As a clerk on the Ninth Circuit, to the best of my recollection, I did not work on any antitrust cases. But I do think that it's an area of the law which, as Lauren mentioned and Kevin mentioned, is really expanding and has a lot of interest now. And as a result, and just as far as the general practice of it, I do think there's a lot of opportunities for young lawyers to become specialists and experts in the field, at least very quickly.
We have a panel on antitrust law with none of our panelists having the traditional antitrust background. I think that does say something about how open the field is. Yet it still is quite intimidating to young lawyers. Kevin, why do you think that is?
Well, it's weird because, the Sherman Act is not very long. It's only a couple of pages, couple of paragraphs, but it's spanned a tremendous body of case law that's constantly evolving. So I think there's a really broad case law out there, some circuit splits that can be sort of intimidating or complicated to dive into, and fundamentally deals with economics, deals with how we compete, how our economy is set up. And so I think sometimes people self-select out because they think I need to have an economics degree or a really solid mathematical, foundational understanding. And I think that one of the things that you should learn in law school, and hopefully you develop early on in your practice, is really a learning and a growth mindset. The fact that you don't have the tools now doesn't mean that you're not going to develop the tools over time with sufficient, work, dedication, and energy. But I think that people assume that they need to have a basis that they shouldn't assume that they need. I think the other thing is it can be tough to find, or it can be scary to find mentors in this space. And that's another sort of myth that I want to disabuse. It's a relatively small bar of antitrust practitioners. And despite the fact that it's made up of people who are incredibly intelligent, it's also made up of people who are really open and welcoming. And in my experience, if you express an interest, they are more than happy to sort of share their experience, their learnings, and to make the path a little bit easier for you than it was for them. But I think, like I said, complexity and just unfamiliarity are probably the two biggest things that stand in the way.
There also seems to be an impression that there are antitrust lawyers who do 100% antitrust, and then there are lawyers who do zero antitrust. Has that been your experience, Jen?
Not at all. So over the course of, let's say the last 5 years of my career, I would say that I've spent anywhere from 30 to 60% of my practice on antitrust, depending on just what other cases have been on my docket and how busy the antitrust cases I have been, particularly how close they are to trial. I think that that's a trend that is likely to continue, particularly as you see more of antitrust challenges and lawsuits that sort of span different practice areas, right? Whether it's challenging a patent settlement or challenging an employment practice, or just your run-of-the-mill challenges to particular industries or the behavior within them as far as alleged agreements and the like. I think that there is a very strong push towards having different perspectives within cases. And I think that sort of the 100% all the time antitrust practice is not certainly not a requirement anymore if it ever was. That's at least been my experience so far.
The other thing I know personally, when I was a law student, I associated antitrust very closely with DC. Lauren is in DC, but you, Kevin, and Jen, neither of you have ever practiced in DC. Is that right? And
Yeah, that's right.
did you ever feel limited by being outside DC?
Well, I mean, we all go to DC once a year for spring meeting, right? So you're gonna touch DC, but no, I didn't feel limited at all. I practiced in Philadelphia for several years, and then I practiced in Portland, Oregon for several years, and I was able to maintain a robust antitrust practice in both places. I think that's because nothing in the law is truly geographically limited, and I think as the pandemic has shown, geography matters less and less than it may have used to. That being said, there is federal antitrust law, but states have their own antitrust laws as well. Almost every state has a mini FTC Act. If you have an interest in competition issues, you're not geographically bound to DC. The FTC's there, DOJ is there, but they don't just limit their actions to DC. They're nationwide, so you can practice anywhere. Might be easier to start there, but there's a path.
Absolutely, I'd say the same. Having been, in a decade, spent a decade in Chicago, and now being based in Texas, and having partnered with lawyers all over the country, my experience has been that while there are a lot of great lawyers in DC, you don't have to be in DC to have a very successful career in the practice of antitrust law.
And I'll add, even though I sit in DC, I've never had a single antitrust case that is DC based, unless they're in the Supreme Court, right? I currently have a case where I'm serving as the outside counsel for a group of 39 states prosecuting Google for monopolization in its Play Store. And the action, it literally spans Alaska to Florida, and it is venued in the Northern District of California with lawyers all over the United States. So definitely, you should come to spring meeting because it's a good time and useful, but you definitely don't even have to come to DC if you want to be an antitrust lawyer.
Yeah, a lot of MDLs, so many MDLs in antitrust land, and they're very rarely venued in DC.
Kevin, when you were first setting out to build your practice, you started at a large law firm. What was it like sort of navigating within the firm to carve your niche in antitrust?
I think this is your mileage might vary depending on your firm, but my firm, so I was at Morgan Lewis and then I was at Perkins Coie, and in both places, I think interest sort of meets opportunity as best as those firms could manage it. So first sort of staying open to that's my biggest piece of advice. Staying open early on in your career to what's out there. You never know what's going to strike you, what you're going to like. But then once you found something that you're interested in, being conscientious about articulating that you're interested in it, and then starting to go out of your way to develop experience, not that just comes to you, but that you can sort of go out and build on your own. I found and did do a lot of this, writing articles, law flashes, partnering with Law 360 to do analysis of ongoing cases was a good way to build not only my internal reputation in the firm, but also start building my substantive knowledge in the antitrust space and developing a reputation outside of the firm as somebody who had an interest in this area. And in my experience, no one at Morgan Lewis or Perkins Coie ever told me, no, don't go out and do external marketing on, on your ability to practice in a particular area. I think those things are rewarded by firms. And I think that they're time consuming. They can take away from billable work, but they pay dividends later on.
I just want to underscore what Kevin said, because there is nothing more valuable than being entrepreneurial in your own career. And that's true of antitrust or whatever you want to do in the law. I mean, for me, I, talked with my mentors about a practice that might be valuable to the firm, decided on antitrust, and then started telling people I'm working on building the firm's antitrust practice so that they knew that. And the reason that I got hired in this Apple versus Pepper case, or got reached out to represent these amici, is because I had told one of my friends who was an associate at a firm. He wasn't like a general counsel, he wasn't a named partner. I'd said, I'm working on building the firm's antitrust practice. And so when this opportunity arose, he kept me in mind. And that's kind of what launched me in antitrust. So, not to be like the secret, but put it out there, tell people what you're doing. And for Law 360, National Law Journal, they're not going to Google you and ask, oh, does this person really have the experience necessary to write this article? If you're a lawyer with an interesting subject in mind, you can in all likelihood publish what you want to publish. So just go out and do it, subject to whatever constraints your organization has about doing those things.
That also ties into another difficulty. Antitrust is a big subject to get around. The statute might be a lot. So for Jen, for someone who didn't take antitrust in law school, how did you go about educating yourself on the topic? Was it through writing articles, or were there any other resources that you've found valuable?
Sure. So at least my initial experience in antitrust law was sort of drinking from a fire hose, helping some other lawyers at other firms get ready for an FTC trial. And so I would say that resources I found particularly helpful, folks have mentioned Law 360. I think that they do a really good job, if your firm subscribes, sort of putting out great articles that may be of interest, depending on what your particular challenge is in your case at hand. I also find that the ABA's model jury instructions are a good resource. A lot of courts use them as sort of the starting point for jury instructions. And so it's good in litigation practice, I think, to sort of have that resource at hand if you can. I think 2016 might be the most recent edition, but other folks on this panel can correct me if I'm wrong on that. But between Law 360, the ABA's resources, as well as your own diligence in doing research, as Kevin mentioned, the statute is very short, and so it's all about the case law for the most part. And so really digging in and having the curiosity and the diligence to wrap your head around whatever particular type of case in the antitrust world that you're facing, I think will go a very long way for you as a young lawyer.
Lauren, you've worked on both the defense and plaintiff side. Have you noticed a difference in that practice?
Yes, but not in a particularly meaningful way, right? So on the plaintiff side, plaintiff side it can be a lot of fun because you're driving the case forward. I mean, the idea is the defendants have your client's money and you want it yesterday. And so you're doing everything you can to advance the litigation to get your client's money back or get injunctive relief, whatever, if whatever they're seeking. So that creates a lot of opportunities. There's also complexities in plaintiff side work. For example, many antitrust cases on the plaintiff side are class actions. Class certification is difficult, becoming increasingly more difficult. There's many cases out of the Supreme Court in the last decade that have made it harder to get classes certified. There's this trend in the Court of Appeals towards not certifying classes when there's some significant number of uninjured class members. So that creates issues. And on the defense side, nobody likes to get sued. Some plaintiffs' lawyers might say, this conduct is really nefarious. These people are, these companies are trying to manipulate the market and this and that. But, at the end of the day, I think most companies are trying to operate their business in good faith. And many companies, public companies have shareholders that they have responsibilities to. They're trying to maximize profit. And we, live in a capitalist country. There's nothing wrong with trying to maximize profit. Sometimes you get crosswise with the antitrust laws. So nobody likes to get sued. It's interesting to try and shoot down theories of antitrust liability as well as advance them. So I like that I can do both in my practice. It kind of have to toggle between those two parts of my brain, but it's fun.
Yeah, do you have a different perspective as someone who's been exclusively on the defense side?
Yeah, I think Lauren picked up on some interesting parts of it, right? You're oftentimes being accused of taking things too far in your business, or depending on the case, engaging in things that might be considered per se unlawful under the antitrust laws. And so from the defense perspective, it can be really interesting and a challenge to work with the company to figure out what the best way to package your case is, depending on the allegations at issue. So having the flexibility to really learn different businesses, if you're privileged enough, as I have been, to work on a variety of different cases in different industries, I think will serve you very well. I mean, you can sort of study things in law school, but when you actually get out and when you're a young lawyer and actually hitting the ground running in a case, having the flexibility to really challenge yourself to become an expert very quickly can really be of tremendous benefit to you in your career.
I sometimes forget this as a litigator, but there is practice outside of litigation. Kevin, were there any sort of the business side aspects of antitrust practice that you enjoy?
Yeah, so I would say there's actually a lot of antitrust outside of the litigated context. When I was at Morgan Lewis and at Perkins, I had a steady diet of litigation, certainly, but I also was called upon to look at mergers and to do some analysis or be part of the diligence process about whether that merger was going to violate the antitrust laws, do HSR reviews, or to just simply review contract clauses that might have impacts on competition. In-house at a company like Intel, we're called upon to advise on business practices, business strategies that implicate antitrust concerns or competition concerns more broadly. And my goal is to avoid litigation. My goal is to make sure that we're legal, ethical, and compliant with all laws, and that means trying to keep us out of court. And so I think while litigation is probably a really good way to build substantive knowledge early, because there's no better way of getting to know something than fighting about it. I think that it's not the only way, and it's certainly not the only way that you're going to practice. One thing that I didn't note before, but and I know we're at an ABA event and they didn't pay me to say this, I'm not getting paid at all, but antitrust law developments is probably the single best source out there for building substantive expertise early. A panel of the ABA on a regular cadence updates 2 volumes with all of the latest, not only on sort of the litigated context, but also merger acquisition type analysis. So it's a really good one-stop shop to start building your expertise. And it's my first stop whenever I have an issue that I haven't encountered in a while.
Speaking of groups of antitrust lawyers, what is the antitrust bar like? Every area of law seems to have its own quirks. Are there any quirks for the antitrust bar?
Sure. So, I mean, I think that one of the things that I've been very pleased to see over time is the diversification of the antitrust bar. You know, in part maybe because you no longer need, if you ever did, to be an economist or work at a think tank or the other sort of stereotypes that you might have about being an antitrust practitioner. That being said, I think that the antitrust bar sort of has a little bit farther it can certainly go over time. I don't think that this panel is a representative panel on gender as far as who you might see in the antitrust world. And so I'd encourage those of you who might add to that, as well as just those who are interested generally, to sort of consider joining us, and also looking to make sure that it's a welcoming place for anyone who might be able to add to the practice of antitrust law.
Kevin touched on this a little bit, but I do think the bar is very welcoming. You know, in trying to break into the bar, the ABA was a great resource for me. And we mentioned spring meeting, which for those of you who don't know, there is a meeting every spring in Washington, D.C. of antitrust lawyers from all over the world. And on the diversity point, it is just incredible to see lawyers from, you know, Pakistan and Belgium all together in a conference room. This year's conference was able to be in person for the first time in 2 years. And it was remarkable. There was one of the main panels was women in antitrust, and they had the heads or former heads of competition from Pakistan, Spain, Mexico, Israel, just all over the world. So it really is a diverse and welcoming bar, and it's, you know, I think it's worth the time to make those connections.
So I guess time now to talk about how our audience members can join that welcoming antitrust bar. Start with you, Lauren, then moving to Kevin and Jen next. What skills should an aspiring antitrust lawyer be looking to build?
It depends on what kind of antitrust lawyer you want to be, right? So I'm a litigator. Having strong litigation foundational skills has been essential to my work in antitrust. I mean, those skills are portable. There's not, you know, if you know how to write a good brief, you know how to write a good antitrust brief. You know how to take a good deposition, you can do the same in antitrust. There is, you know, there is some economics that you're gonna learn as you go, or have to educate yourself on at some point. And I think we've mentioned various resources you can turn to, but I think just, you know, trying to build the kind of foundational lawyering skills that you would for any practice and then bringing them into antitrust is really what I would suggest.
Kevin, what about you? What are there any particular skills you'd emphasize?
I would echo exactly what Lauren said. I think the first thing you have to do to be a good antitrust lawyer is be a good lawyer. So I think focusing on your ability to critically analyze cases, if you're going to be a litigator, is important. Figure out what actually matters. Figure out what the holding is, what the facts are, why the court went one way as opposed to another way. That's like sort of, you know, basic blocking and tackling. But the reason why the antitrust case law is as expansive as it is because the facts matter. You have to be able to sort of master those and manipulate them to the best of your ability. And then I think this isn't a skill, it's a mindset. And I've said it at the beginning, I'll say it again, like just adopt a growth mindset. You're not going to be able to be an expert the first time you approach a case. Take something, learn something from every opportunity that you have, and build your experience block by block. There's a lot of growth that's going to be required to become a good antitrust lawyer. It takes 10,000 hours to become an expert at anything. So you're gonna have some work to do. So just embrace the work and embrace the learning, and don't get too discouraged if it's coming slowly, because you'll hit peaks and valleys.
And just to add on that, you also should not be afraid to fail. You should not be afraid to tell people, I don't know every single thing about antitrust. I am learning. Please help me learn. People want to help you learn. You'll be surprised how many people want to mentor you. And on the failure point, one of my partners likes to say, if you're not failing, you're not trying hard enough. You're gonna fall down, and the most important thing is that you learn from those failures and take that lesson forward with you in your career. That's true of antitrust and life, I guess.
I think that those are all great points, and really just embracing all those skills that you get on any case, whether it's antitrust or otherwise, is really critical, and looking to bring the skills that you've developed, no matter the practice area, into antitrust really is a good way to become very valuable and to make your mark in this practice.
Sticking with you, Jen, for a young lawyer, if I were working with you on an antitrust matter on your team, what as a junior lawyer should I be trying to do to add value for you and for the client?
Sure. I mean, if you're working with me, I think being curious and looking to run down issues. Don't assume anything, right? Don't assume somebody else has already thought of it or that you can't be of use. There's no substitute for being a good researcher and writer, I think, particularly as a junior lawyer. But also, being willing to speak up and to add your perspective, and to be able to come to the table knowing that you really are a valued member of the team. And, it's really incredible. I think that a lot of antitrust cases are staffed fairly leanly, at least in the litigation side. I know in litigation boutiques they are. And so you have the ability to be useful, and as much as you'd like to take on, if you're working with me, I'm happy to have you do that and to work with you to give you the skills and the tools you need to do that.
And I know the work is largely similar, but Kevin, as a former big law antitrust lawyer, is there anything specific advice you'd offer to a law student who's preparing to join a big firm that already has a robust antitrust practice?
Yeah. First things is make your interest known. I think we've talked about that a fair bit. Look for opportunities to partner with people, not only on cases, but outside of cases, where you can develop, substantive knowledge and experience. Shadow as much as you can. If you can't get on a case or there's not room because there's billing considerations, one thing I used to do was I'd ask, hey, can I actually tag along to that? We don't have to bill for it. I'll bill it as training and development. If there's concerns or whatever. But I just want to see how one of these calls with the FTC goes when they're doing a civil investigative demand. And client might not want to pay for me to be there because it's a small matter, but I want to see how it works. So just express an openness, a curiosity, and interest, and try and suck up as many opportunities as you can. And then I think when they come around, take full ownership of them. I think one of the things that, there's an incentive in this as an associate is to just sort of focus on the task at hand and to really sort of nail the task at hand. And that's great. You need to do that. But I think you also need to think about where your piece fits into the overall case. And so I tell people now, take ownership of the whole case. Think that it's your case. It's not just this memo. It's not just this section of the brief. This is my case. And I need to figure out where my piece slots in overall. And all of a sudden you'll start seeing things fall into place that you might not have if you were only focused on, the statute of limitations arguments or the tolling arguments as it applied to, this class action.
Lauren and Jen, as former law clerks, is there anything current or future law clerk should be thinking about to maximize their experience for a career in antitrust?
So I'm going to fight the premise of the question a little bit. So maybe Jen wants to give a real answer, but I think is the answer I would give, because I think while you're clerking, you should, Kevin said this, you should have a growth mindset throughout your whole career and your whole life, particularly while you're clerking. When so I clerked in district court and then I clerked in the Court of Appeals. And when I entered my district court clerkship straight out of law school, I thought I wanted to be a public defender. And I thought civil litigation was really boring and I would never want to do that. And then I had the privilege of working on a 3-week-long contract dispute between ESPN and Dish Network. And it was anything but boring. It was really interesting. And like saying it now, you all don't believe that it was actually interesting, but it was. And it sparked my interest in civil litigation. And then on the Ninth Circuit, I was very unsure about what I wanted to do because I had just been kind of like unmoored from what I thought I was going to do, and was very open to all sorts of different kinds of cases, and then ended up joining a firm that allowed me to continue to explore with that open mind until I found something that really fit. And I still do many things that are not antitrust. I'd say maybe now half my time is antitrust, but I wouldn't do anything to prepare for a career in antitrust going into a clerkship. I would, however, encourage you to read many opinions of your judge before you start your clerkship, but that's just clerkship advice, not antitrust advice.
No, and echoing, I also clerked on the Ninth Circuit, same as Lauren. So just to echo, having an open mind and really just embracing the different types of cases that will inevitably come across your desk as a clerk. There's no substitute for being a good writer, though, and so certainly, if you're thinking about clerking, I think it's great. And also no substitute for having the privilege to work closely with a judge who himself or herself will have also been tremendously successful, oftentimes in litigation. And so I think that having that experience and just really trying to make the most of it, learn as much as you can. At least for my clerkship, I thought that one of the most interesting things was learning how my judge worked with other judges and how he sort of navigated that, and getting to see behind the scenes how things are actually decided is tremendously useful. And if you have the opportunity to clerk, I would encourage you to take it.
And you guys should really listen to Jen, because she managed to get this amazing opportunity that also allowed her to live in Hawaii for a year, clerking for Judge Clifton. So she's winning. She's winning at life.
Thank you, Lauren. I would encourage you guys to anyone on any of the circuits or district courts would be amazing to work for, but Judge Clifton was an amazing judge, and also was very amazingly located in Honolulu, Hawaii.
We talked about this a little, that how antitrust comes up a lot even in the general public news these days. Kevin, do you have any tips for either the aspiring antitrust lawyer, the law student, the practicing antitrust lawyer, how to keep current?
Yeah, so Google Alerts are your friend. I would actually encourage you to set a Google alert for the Sherman Act or for antitrust, and then every day you'll get a daily digest of the top articles that hit on those particular cases. It's pretty broad, right? So if you're looking to just sort of dip your toe into the water or the ocean that is antitrust, that's a good way of starting. But also sort of Law 360, if your firm subscribes to that, there's a competition daily newsletter that you can get there. And then just those are like two really good sources. Joining your ABA antitrust committee is good. Getting plugged into your firm if they have an antitrust practice is good. And then I would just say, like, honestly, read like a news aggregator like once a day. People used to say the newspaper, but like I go through like Google News. You'll be shocked at how often antitrust issues are coming up. I mean, just last week there was an exoneration, or exoneration isn't the right word. There was a not guilty verdict in the DaVita antitrust case. The first a criminal first a criminal case in the labor market, focused on no poach agreements. DOJ lost that case. That's an antitrust case. You might not have known it was an antitrust case when you just see DaVita and executives beat indictment, but it was an antitrust case. So just paying attention and reading the news, I think you'll see it come up a lot more than you might think.
Oh, definitely echo what Kevin said as far as those all being great resources. I might add to that as well, Westlaw or whatever sort of research tool your firm subscribes to. Oftentimes you can set up alerts specific to a case. And so one of the things that I found helpful, for instance, on the reverse payment cases, is I have an alert anytime something comes out that cites Actavis, which is sort of the preeminent Supreme Court case that changed the standard or clarified the standard for those types of cases. So anytime there's something that cites to it, I get a notice. And so if you're working on a case as a junior lawyer, particularly if you're the one tasked with figuring out what, if anything, you should file as far as motions practice goes, that can be a real time saver and just something good to make sure that you're not missing out on a major development in the area.
I would just add that, look out for CLE programming. It's a great way to just, have experts in the field update you on what has happened, maybe not on a day-to-day basis, but over the last year or so. And, what are trends that you should be looking out for? That's another great way to, stay up to date, but also to educate yourself in a more meaningful way.
Now that you've all had some success in antitrust, looking back, are there any lessons you wish you'd learned earlier that you can save our audience members some time?
Sure. So I think that I wish I knew earlier how much fun practicing in the litigation field was going to be, and how, how meaningful it has been to have the privilege of working across the aisle, as well as on the same side of the V, with so many different talented lawyers. No one's an island in this practice, particularly given how large these cases tend to be. And so I think that as a young lawyer, as a law student, there's no substitute for really taking advantage of the opportunity to meet and work with lawyers across the aisle with you on cases at your own firm. And as Lauren mentioned earlier, that can really be a source of great opportunities to come.
I think Jen got it right. Something that they don't really convey to you in law school, and that I didn't understand for a while, was until I was in private practice, really, is that, this is a people business. Your classmates, if you're in law school, will be your clients. They will be your co-counsel. They will be your opposing counsel. Some of them will be your judges. And careers are long, and people remember you for better or for worse. So be nice. And particularly in litigation, we're on the opposite sides of the V. We all have a duty to advocate for our clients, up to the bounds of the law, and we're all zealous advocates. And sometimes that can bleed over into thinking the other side are bad people. But that's not the case. And they're not going to be on the opposite side of the V from you always. At some point, they're going to, be thinking of opportunities that might be suitable for you. And if you were not good at your job or horribly unpleasant to work with, that may, implicate opportunities in the future. So it's important to be a good person generally, and that remains true in an antitrust practice.
I think the only thing that I would add that I didn't know going in, but I wish I knew, was how well antitrust suits transition to business or counseling a business directly, because you see so many different types of issues in both a litigated and a non-litigated context, because fundamentally it's about how we compete with one another in the marketplace fairly. You get exposure to business folks in a way that you might not often get exposure to business folks in a more traditional commercial litigation setting, or even in a transactional setting. You might not focus on this particular area, or might only focus on one particular industry. I think antitrust makes you uniquely prepared to touch many different types of industries, focused on many different types of business issues, maybe better than any other sub-discipline of the law.
Before we wrap up, I did want to turn to a couple of questions from our audience. Our first question comes from an international lawyer who's looking for advice on how to get into the American antitrust market. Lauren, do you have any advice?
I mean, it depends what you're looking for. And I should say, I don't know if our contact information is provided as part of this panel, but I'm happy to connect with anybody. So feel free to email me. You can look me up on MoloLamken's website. So antitrust obviously has an international dimension to it, but there are many, there's different enforcement entities in every different country of the world. If you want to break into American antitrust, there's going to be, it's a different legal system, there's different doctrines, but the basics of understanding how competition works that's a portable skill. So I would, emphasize that. And if you're interested in getting into private practice, there's ways to kind of bridge the gap, right? So you can do, there's international arbitrations that might have some competition aspects to them. There's all different ways to do it. So it really kind of depends on what you're looking for. I don't know, do you guys have anything to add? I feel like that was kind of nebulous.
The only other thing that I would sort of put with specificity around it is look for places where the United States and other countries, not necessarily at the governmental level, but in business, cooperate or collaborate regularly, because that's going to be an area that's going to be rife with antitrust issues. So one that comes to mind is standard essential patents, right, or standard setting as it relates to technological innovation. You've got a bunch of businesses working together to put forward a new standard. Oftentimes when businesses are collaborating on something, there's going to be an antitrust issue there. There might be an antitrust issue from a European law perspective, from an Indian law perspective, and from an American law perspective. So it might be a place, if there's a Venn diagram where you can sort of center in on the middle. That's about as practical of advice as I can come up with right now. But I think Lauren's point is exactly right. Just build the basic blocking and tackling skills, and those will serve you well.
Another audience member wants to know what advice you have for how to build a network that can be a future source of business. So in addition to being nice, is there anything else that you can offer this audience member?
I mean, I said being nice, but I think probably more important than being nice is being good at your job. You should, I joke, but you really should strive to become the best lawyer that you can be, because that's who clients want to hire. They want to hire the person that's right for this job. They also want to hire somebody who's pleasant to work with. So that's where that comes in. Building a reputation for yourself is important. Kevin mentioned this before, writing, speaking, getting your name out there so that when people, honestly, clients have come to us simply by Googling, okay? It's not like you have the secret Rolodex, back when those existed, that's going to get you all your business. Having your name out there really will do a lot for you. And then kind of building relationships one-on-one, if there's, keep in touch with your classmates from law school, keep in touch with your classmates from undergrad, just making sure that you have a network that will keep you in mind, knows what you're doing. And then, opportunities will kind of come from that, as long as you're being proactive in that regard and building your skills, I think. I don't know, Jen, what do you think from your perspective?
No, I think that those are all great pieces of advice. I think that really your reputation is something that you should take very seriously, and building one can be as simple as doing a good job on a case, even if it's not antitrust related. Being at a litigation boutique, I will say that we have been privileged to work with larger firms who may have conflicts. for a given case. When you talk about sort of breaking in on the defense side, that can be a really interesting way to be involved in a case if the current counsel is unable to serve that third party subpoena or put on that third party witness at trial because they have unwaivable or otherwise conflicts that will prevent them from doing so. Working on one area of practice and doing a great job there can, particularly on the trial side of things, right? I do very strongly believe if you're a good trial lawyer, you can try pretty much anything. And so building those skill sets, to echo what I know Kevin and Lauren have really emphasized throughout, you really do, as a young lawyer, have the opportunity to work very hard at being a good practitioner. And at least if someone finds a secret to do this without working hard, please do contact me as well.
Yeah.
Is on Goldman Ismail's website, but there really is no substitute for hard work, particularly at the early stages of your career, and being somebody who tries to always put terrific work product forward, whether it's sending an email, writing a brief, arguing in front of a judge, building that reputation for being a terrific lawyer really does pay dividends.
Yeah, and so I'm no longer in the position of having to go out and hunt down business, right? I'm an in-house lawyer, so I look to hire lawyers now. But I think that what I tried to do when I was in private practice, the same thing I look for now when I'm engaging with other lawyers. It's about credibility, right? It's about trust. I want the lawyer who I trust knows the issues, but I also trust them to counsel, like tell me the truth, not just what I want to hear, but tell me the truth, and to help me navigate those particular risks. So I would say, in addition to everything that, build your substantive expertise, put yourself out there, collaborate, all of those things, but tell the truth. Be honest and help your clients solve their problems. And the only way that you can do that is by being credible, and finding a way to deliver bad news is a skill that I think will make you much more successful than running from it.
We have another question from an audience member looking for advice on what experience might help a young lawyer break into the healthcare antitrust field. I think Jen and Lauren, you've both handled antitrust matters in that industry. Do you have any advice?
Sure. So my experience has been primarily on the pharmaceutical side of things. And so I think that much like being flexible and curious on the economics piece of antitrust, you can also really serve yourself well by understanding some of the science that might come behind some of the challenges that are being made to the industry, working with the business people and having that credibility that Kevin mentioned, where they know that you are going to have their back, that you are going to be prepared, that they're not going to be, if you're defending, for instance, a business person in a deposition, that there's not going to be huge surprises. I think that all those things really do go a long way. I don't know that there's any particular, much like antitrust generally, I would say that there's not a specific requirement that you have, or that a box you have to check off in order to be successful in defending or prosecuting, for that matter, challenges in the pharmaceutical or healthcare more generally space.
Yeah, and I agree with that. The only thing I'd add is if you know somebody who's familiar with the space because they have some kind of public health background, or maybe they're a healthcare lawyer, even though they don't know antitrust, like ask that person if they want to get lunch or, have a Zoom meeting and just pick their brain a little bit. Just trying to see what resources are available to you and have a conversation.
I think we have time for one more. And we've touched on this a little in the practical space of writing articles and getting your name out there. But Kevin, do you have any insight for how sort of an academic legal writing might open doors to jobs in the antitrust field?
I don't know about a direct correlation, right? Like you're writing a law review article isn't directly, or very rarely is going to directly lead to a job, but what it's going to give you is the a product that you can put in front of somebody and say, look, I did this. This is my knowledge, the synthesis of my knowledge. So it shows someone that you've invested in invested the time and the research needed to sort of master that particular subject. The other thing is it can be an educational piece, right? You can use it. If you've got your Google alerts set or something like that, and you see a company is facing an issue that touches on the academic article that you wrote, you can send it to them and say, hey, I actually have some familiarity with this issue. I'd love to help out. How can I help? Like sort of putting yourself out there. And then I think the third piece is, even if it's not necessarily about antitrust, a lot of what I focused on in law school was about negotiation and negotiation theory. But like I wrote law review articles on it. I put those things out there because it told people that I was savvy from a business perspective, right? So being able to tell people, well, I might not have this skill that you're looking for, this antitrust specific skill, but I have something that's adjacent that I'm going to be able to leverage to add value to this team that already has the substantive experience that I'm trying to draw from. So that's sort of how I would approach it.
We actually had one more question come in asking if there's any opportunity to work on antitrust issues in the art and entertainment areas. I don't know.
I'm certain that there are, because those are businesses like all businesses, and you could theoretically have like a talent management agency that decides to allocate markets with other talent management agencies, and that's an antitrust problem. I'm not, no cases come immediately to mind, but at the end of the day, antitrust is about how businesses operate in our economy, right? And these are businesses, so there will be antitrust issues. So just look out for them, I guess.
Sure. Yeah. Just to add to that, I mean, in a dispute about retail, in the retail industry, there was opportunities to have third-party witnesses that were in the entertainment space and make those connections through that. Also, I know on the no poach issues that there's been some challenges that are directed specifically at some major entertainment businesses. On the art side, I haven't personally come across anything as of late, but I have no doubt that if there is a challenge to be had, it's something that can really affect and therefore become an area for you to develop as a lawyer across industries, whether it be art, entertainment, pharmaceuticals, healthcare, or otherwise. It really is a very fascinating space insofar as you can become an expert very quickly in various industries as it relates to antitrust because of the impact touching on so many different types of businesses.
Yeah, I think professional sports is a really big one. I think antitrust concerns are super big in professional sports because they're exclusive by nature, right? There's only 30 teams. You can't buy another team unless the league opens one up. And I've been trying to break into that area forever. So if there's anyone here on the Portland Trail Blazers who's looking for an antitrust lawyer, my hand's raised. Just trying to model the behaviors that we're talking about. Put it out there, it'll come. But yeah, I think I totally agree with Lauren and Jennifer. It's there everywhere. It's not industry specific. It's about our economy. It's about how we compete with one another. So if you want to pursue an industry, pursue it. And this is an angle to get there.
Well, we've run out of time, but I really want to thank all of our panelists and all the audience members for attending. This has been a great discussion. And I hope we can continue it another time. Thank you so much.
Thanks for organizing.
Ken, for organizing.
Thank you, Ken. Thank you, everybody.